Mr. Kevin,
I can hear you. So.
Excuse me, I need to.
I like that.
I think we can proceed.
Judy, come here.
We're going to end up on YouTube again.
Yes. Yes, you will. But that's because you're so freaking adorable. Now, it's time for some small claims court, which is second most to traffic court.
All right. Back again.
All right, Mr. Hall, did you hear any of that I said already?
I had a little bit of computer issue there. My apologies.
All right. This is file 232157SC, Earl Hall versus Zeppi Slevat. This is a small claims case, meaning you guys are asking for this to be decided here in front of me as opposed to having a jury trial. We're also in small claims, meaning you do not have attorneys. If the parties agree to continue here in this fashion, you are foregoing your rights to use attorneys or to have jury trials. But if you're both prepared to proceed at this time, the first thing I'm going to do is swear everybody in who might be testifying. Please raise your right hands. Swear or affirm any testimony you give here would be the truth, the whole truth, and nothing but the truth.
I do.
Yes, sir.
All right. So my question here is to, I only have so much information when we start these. And so Mr. Hall, at some point in time, you made a, let's call it a personal loan to what person?
It was to Zeppi Slevat's husband, Joe. It wasn't one loan. It was a series of loans over a series of many years. It wasn't just one thing. It was a loan of money here. They need a little bit of money here. Every time I would go visit them, they need money for this or for that. And I bought them a well pump. So there's lots of different things. There's not one thing that it pertains to.
All right, but did you do a written agreement that this money was to be paid back?
No, if you look at the notes that I gave you, she did pay me back regularly up until her husband got very sick, and then she sent me a note saying she couldn't pay anymore because the doctor bills were coming in and she would catch back up. That's been 2 years ago, and her agreement was really good. She was paying very well up until the time again where her husband got sick. And I expected her to be forthcoming and start repaying the loan on her own without me having to ask her to do this. And she ignored all my requests. So I'm forced to come here to try and get the money back.
All right, $4,475 is the unpaid balance.
Correct. And that's in her handwriting.
Right. Well, Ms. Levatz, let me start with you. Do you believe that there is a dollar amount here that you owe Mr. Hall, and it's more about how and when you're able to pay that? Or are you here contesting that you owe him money?
I'm contesting it.
And why?
The loan was made at a time where my husband was having problems with his inheritance with his brothers. They had taken over our property. I provided the court with 2 exhibit files of information helping to prove what I'm saying. The loan was directly related to my husband's inheritance. I wasn't working for the entire 31 years that I was married to Joe. The loan was actually created in 2016, and the loan was only stopped paid on because Joseph Slevatz passed away. Mr. Hall was
okay.
Mr.
But ma'am, you understand if you are married at the time that that loan was taken out, that is a financial obligation to both married parties.
This fortunately gives me a chance to clarify something I misstated in a previous stream. Michigan specifically is not a community property state. Many states are community property states. Michigan is not. Michigan has very different rules when it comes to marriage and property, which we're not even going to get into. But in Michigan, if a credit card loan, whatever, is held in the name of one spouse, but not the other, and the spouse that owns it dies, the other spouse is not responsible for it. However, if the debt is in both names and that spouse, one spouse dies, the other spouse is responsible for it. So the key to it is, are both names on it or just one?
Yes, this is why Mr. Hall was asked to file in probate court, because the person that he loaned the money to, and he specifically said it himself that he loaned it to my husband, not to me, passed away. And because he passed away, we asked Earl to file in probate. Earl would not file in probate.
That's a mistake as well, Your Honor. After the very first trial, I contacted the probate court in Kalamazoo to ask them directly if they had a case for Mr. Slevatz. They said no. I called again several months later. Again, the answer was no. There was no
With-
pending case, excuse me. There was no pending case.
Ma'am, did you file a probate case for your deceased husband?
The filing is in the exhibits provided to the court that Anthony Sleevots's estate, which is my father-in-law, was filed in Kalamazoo, and all trusts and estates are filed under that because that estate created it. And that would be the Joseph Robert Sleevots, my husband.
Okay, but here's the problem, ma'am. Mr. Hall going after this in probate would be because the person who owes him money is dead. The person that owes him money, I'm talking to. It's you.
Now, he admits in his own paperwork right here that he filed in court his exact words. On July 4th, I went to Kalamazoo. This is where it is. I given instructions in July 10th at this court, small claims hearing, to file in probate court to recoup the money owed from the defendant's deceased husband. Not from me, sir. From the defendant's deceased husband.
But ma'am, and he can do that, but he can also pursue it from you. You've signed off on this, that you're making payments.
My husband was making payments. I was never making payments. I had no income.
Your signature's on the document.
Ma'am, let me just tell you, he could go through probate to get that money, or he could say that he has a contract with you and your husband. It does not mean that you no longer have a contract because your husband is deceased. You are part of this contract. So he has a contract with you that you owed him $4,900, paying it off, looks like $25 or maybe $100 a month here. Got that balance all the way down to $3,600 and then gave more money, right?
Yes, there was only
52.
Yes, there was only 2 loans together. Altogether, only 2 loans.
All right. So who benefited from these loans, ma'am? What did you do with the money?
My husband. He took the money and he fought his brothers in probate until we got control of our land back.
Okay. So you got a benefit from this loan.
I guess that's how you see it. I don't see how I benefited from it. Every bit of that money was given. I never benefited. You can read the trust. I never benefited in any way, shape, or form from the trust or inheritance. And my husband used every bit of that money to fight the trust and inheritance. And I never benefited from any of it.
Well, that's his choice. But this person loaned money to a married couple. They used the money for whatever purposes they chose to use that money for. And he expected it to be repaid. Repayment was started. One of the 2 people passed away, and now the other person is saying, I don't owe that money anymore. That's what I'm hearing.
No,
so
I never
I'll give you a chance to explain to me how that is not the case.
I never owed it to start with. Everybody understood that. That was the case. And Mr. Hall had
Why did you sign this?
It was supposed to, there was supposed to say a CO in front of it. If you look up the paperwork for the trust where it has Joseph Robert Sleevots' name on it, it has name on it as well.
October 7th of 2015. Why did you sign it?
It was a naive mistake.
You are Ziffy, right?
It's when I first became power of attorney fiduciary and I didn't know what I was doing. And I made the mistake of signing it above my husband's name, and I made the mistake of signing it without the CO, which is on the trust paperwork. It's just a naive mistake because I didn't know what I was doing. I didn't have any money. I never made any payment to Mr. Earl Hall. Every one of those payments was done.
When did Joseph pass away?
The death certificate is right there in front of you in the exhibits. Joseph passed away 8/14/21.
Okay, ma'am, I'm talking about this that you and Joe both signed, saying,
Yes,
we owe this money back. It's a loan.
I know. I provided it as an exhibit. That's correct. With the actual balance, which is $4,375.
Okay.
There's a complete.
But now you're trying to say you don't owe that money.
I don't believe I do owe that money. My husband owed the money, and when my husband died, Mr. Hall had 730 days ample opportunity to file in probate for a rather large inheritance that was more than capable of paying the loan. I have given you exhibits of pictures of the trailer I live in which is almost condemnable. My car broke down today and I am in someone else's vehicle. Mr. Hall knew about the inheritance the entire time and is just
Ma'am,
refused to file in
listen
probate.
to me. Listen to me. You are right in that Mr. Hall could have used that route to get his money back. But he also is entitled to use the route he's using right here, in that you signed a contract to pay this money back with him, and now you have stopped paying money back.
I never paid him to start with. My husband paid him and my husband died. That's why the payment stopped.
Ma'am, marital debts are the debts of both parties. That's how marriage works,
Well,
as far as the law is concerned.
Well, that's why those creditor companies actually went into probate and took care of it, and all other creditor companies, which would be the MasterCard and Care Credit, they just removed the bill entirely because of his deceased. So nobody
Yes.
else, literally
And
no
Mr.
one else.
Hall, Mr. Hall could, if he wanted to, say, you know what? I don't need that
Yeah,
money
this could
back.
be a
It's
deal.
okay. But he
Right.
also has every right to say, I want the rest of my money back.
He
I'm just
can't.
trying to figure out if you have any other
The inheritance
legal leg
had-
to stand on other than you think he should have gone through probate.
No, I don't think. I'm saying I know because the inheritance had it to give him, and I never made that agreement to pay him, and he knows that. And I
Well-
don't have a penny to my name. I can't even go to work today because my car is broke down on the side of the road.
Ma'am, your inability to
Somebody
pay
else's
is not a
vehicle.
defense to whether or not you have to pay,
No,
right?
No, that's not my point. My point is the inheritance had the money to pay him in full. And if he wanted to be paid in full, he would have filed in probate. Now, he also has a motive to ignore probate and go after me. And that was the state police complaint that was made on the second month in 2018 to the State Department, Sheriff's Department, State Police. I filed a complaint with my husband and it made Mr. Hall very angry. And he informed us then that he would never go into probate and file in probate and he would always come after me with that loan. That is his
Okay.
motive.
Ma'am,
not
you may
filing
be
probate.
explaining
I'm trying
why
to.
he's choosing to do that, but you're not giving me a reason why he can't do that.
I do not have a way to pay the man. I'm practically homeless.
Okay, but your inability to pay has nothing to do with whether or not you have an obligation to pay.
No, I agree
understand
with
that-
you. I agree with you
Okay.
on that, Your Honor. However, I happen to know for a fact, just like Mr. Hall knows and God is my witness knows, I was never intended to pay that loan back. Mr. Hall knows that.
Well, unfortunately, ma'am, you signed the agreement to pay it back. That's what I'm stuck with. All right,
Yeah, the paperwork
so
was-
I would make
paperwork
a
was filled out
finding
incorrectly
here,
because of my naivety. I agree. So that he'll chase me.
$475 in damages. He's also able to recover the $82 he spent in costs getting here. That was a filing fee that he paid out of pocket to court and a fee to have you served. But he's also able to recover that, just so you know where that extra money comes from. So on this, it will end up as $4,557 altogether on the judgment. Now, because we did go to a hearing today, both parties have the right to appeal. If you choose to appeal, you must do so within 7 days of today's date. That window of opportunity closes, and you must do that in writing. Do you understand your rights on appeal?
Yes.
Yeah.
All right, then we are all set for what we needed to do here today. I'm going to go ahead and release parties. Thank you.